welcome back to Legal Alternatives Podcast. Me, SamPawson, joined as ever by Nils. Nils, how's things? Are they good, Sam? You? Yeah? Nearly kind of mid-heat wave, not too bad in Leeds today. A few weeks left of the summer, but yeah, another action-packed pod as always. I think I'm kicking us off this week with, it's going to test our age, Nils. We're talking about GIFs today. I know you love debating the inner workings of the Employment Rights Act and the Equality Act. We're going to talk the difference between purpose and effect in harassment case. So I'll give you, the case is recently, it's a COVID case, but again, introduced the battle of the tribunal, something that's just kind of got through the tribunal. So it's the claim is a Miss Ursulanu employed at Vickers Cross Healthcare. So Ursulanu and Vickers Cross Healthcare, case reference for anyone who wants to look. I'll give you the background. The background's quite important in terms of the facts. It's quite fact specific, and then we'll get into the law. So the claimant, Miss Ursulanu, worked as a security guard during COVID for a pharmacy that ran a vaccination centre. Number of security guards and the usual cases we're seeing, team WhatsApps and also personal messages. Background of the case is that the claimant struck up a friendship with a Mr. Ray. In February 2020, after a fire inspection, the claimant sent a message to Mr. Ray saying, "Hi," which he responded with a GIF that said "drama incoming." The claimant followed that up with a message that said all staff needed to sign fire risk assessment and the fire extinguishers needed to be tested after the inspection. She sent three other messages confirming that instruction to Mr. Ray, who responded, "Already sorted today, don't worry." However, when the claimant then sent a thumbs up emoji, Ray sent a GIF that read, "Bitch, I'm lying," before saying that he would sort it out soon. Claimant replied saying very professional, and Ray responded with a GIF of Jim Carrey with a sarcastic smile. So that's your background. Again, one of these cases seemingly relatively mild comments. There was some background also need to be aware of. Claimant in previous messages, not from Mr. Ray, but from an other employee, had been told that she went to school with Vladimir Putin and was acting like Putin in her messages to other members of staff. After the incident, Mr. Ray apologised to the claimant, saying that he simply typed the words GIF into the search box with the words "I am joking," and that GIF came up. And he also argued that himself as a gay man, the term "bitch" was common usage and actually wasn't kind of connected to the claimant's sex. Claimant again said that she was upset by the comments and brings a standalone claim in discrimination based on harassment to the tribunal, holding her employer obviously vicariously liable for the treatment. Tribunal's findings were quite interesting. Let's say we'll get into the actual findings, which are kind of key in harassment. So we've talked about before in harassment claims, what you're looking at is any treatment which has the purpose or effect of violating an individual's dignity or creating an intimidating, hostile, degrading, humiliating or offensive environment. Findings of the tribunal are quite important, that they held that the statements from Mr. Ray did not have the purpose, so there was no intention to obviously intimidate or violate the claimant's dignity, but it had the effect of. So quite interesting when we say purpose or effect. This is a case that's actually said, because often in cases it goes along, it's the purpose and the effect often. This is a case that actually they did find that it did have the effect of violating the claimant's dignity on the grounds of her sex. And also obviously the connection to the comments about Putin obviously also found that
intimidating environment. Again, that in that case linked into race as a Romanian individual. So claim found, harassment found, and claimant was awarded £11,000 in unduty fees. Relatively low amounts on average, so that's obviously for the experts in the room, that's a mid-vento award, so not a huge amount of compensation brought as a standalone claim. Or again, interesting always, these cases aren't always where people resign, they can be brought as standalone claims. But just thought it's a really interesting case to do those two things that we often see in practice. People say, well, I didn't mean that, or the person's being sensitive. It's not always what your intent was or an employee's intent was, it's actually what is the effect of those comments. So quite an interesting case, I thought, to bring to clients' attention, good listeners' attention, lots of kind of takeaway. And any views, Nils?
I'm assuming there wasn't a policy, but you said Vickers was the defendant.
Yeah.
There wasn't a policy saying this is what we expect, because that would have been extremely useful, wouldn't it?
Yeah, exactly. No terms of policies in terms of kind of harassment, quality and diversity policies in terms of how we are dealing with comments between members of staff. Again, nothing I can see from the case report about any training as well, which I think is also often important in these cases. But it's another one that we can see that I can quite understand that some listeners may say, well, this is not the most offensive things that are said. You see this all the time, and it is, you know, employees are held to an incredibly high standard.
Yeah.
And things that can be seen as joking, or that dreaded word banter, you know, can still result in, you know, not a huge award, but still significant, obviously compensation to the claimant, and we're not forgetting legal fees and others involved. So it's going to be probably a £20,000-30,000 kind of cost to the company if they've engaged lawyers on the case.
Yeah.
You know, costly mistake for probably lack of training, lack of policies, and obviously controlling an employee in that group.
We did a health and safety presentation in my team yesterday, and we made it clear to a client, so we made it clear the trend is going towards protection for employees.
Yeah.
And a lot of people will say, well, that isn't very offensive. I think it is quite offensive. Yeah. But it just goes to show, having that training could have saved a lot of time, and you would have been finger pointing at the employee, wouldn't you?
Yeah.
You told them not to do this.
Absolutely.
Totally different case.
So yeah, lots of takeaways as always. Any advice on policies, training, let us know. Happy to kind of help any listeners. What's else we do with modern slavery?
Yeah, so sort of an employment law matter as well. So it was actually due for its second reading, the new proposed immigration and asylum bill in Parliament yesterday. So as the pod goes out, there may actually be an update that we might do next week on this. But some fairly significant changes to how the government wants modern slavery reports to be made. So at the moment, if you have a turnover of £36 million or more, which actually is a lot of money, but in terms of business turnover, not huge. You don't have to be a huge company to turn that amount of money over. You're required to publish and prepare a slavery and human trafficking statement. What the proposed changes are is to try and strengthen that. So amendments to what's called Section 54 of the modern slavery regime, with penalties, new penalties proposed as well. So at the moment there is no prescribed content from modern slavery statement. What the government is proposing to do is make certain aspects of the modern slavery statement mandatory. So they're going to have to, it's the same as current, but that will become mandatory. The reason for that, the government says, is to emphasise accountability and for organisations to actually explain why they haven't taken certain steps, so that will become mandatory. And one of the examples given is that organisations will need to disclose any due diligence processes on modern slavery policies they have in place, or explain why they have none. So you are required to publish a statement, and it will be mandatory to say if you do have a modern slavery policy or if you don't. So that will become mandatory. Dated certification and approval requirements. So at the moment, statements must be signed. Under the new proposal, what's called an accuracy statement would also need to be given. The law is going to be extended to public authorities, so that will be relevant. Fly getting in my way there. That won't be relevant to most of our clients. New requirement to actually directly submit to the Secretary of State by what's called specified electronic means. What that's probably going to be is uploading to what's called the Modern Slavery Statement Register. At the moment, that's not mandatory. Crucially, which is what most people want to know, new penalty for non-compliance, and quite significant. So unless you have what's called a reasonable excuse, there will be a financial penalty for not meeting these requirements. The penalty cannot exceed the greater of 1 million or 1% of your total turnover, or if you're a public authority, the public authority's budget. So fairly hefty. Fairly hefty. There are some criticisms of this, whether they get plugged during the reading, which was yesterday, I don't know, so we'll have to update people on that. But the Independent Anti-Slavery Commissioner has said that the new requirements are not going to include mandatory human rights due diligence on supply chains. So that's a criticism for them, and we'll see if that gets plugged. But some fairly, I think, basic changes. I don't think it hugely shifts things, but not complying with this could carry very, very significant fine.
I think from my experience in assisting clients and companies with this, I think I agree that they're relatively minor changes, but I think there is some sense in the changes that have been made. The statement at the moment it is so, for want of better, and wishy-washy and vague. It's say anything about obviously the processes to kind of prevent modern slavery. So I think lining that up with the policies does make a bit of sense. And again, obviously, as you say, what these provisions are all about is to try and prevent something absolutely horrific. Any little hopefully will help. The penalties there, as you say, are quite significant.
I would be interested to see in 5 years' time the stats for how many people do get fined. I think that's the key, isn't it? You can have a penalty, but where's the teeth?
I think for me, the real changes, and I say this when I talk about equality reporting, so gender pay gap reporting, the threshold is the issue for me. The threshold that is quite a significant size company. That's the top 1% of companies that will be caught by that threshold. Similar for equality pay gap reporting, or actually, if you look at some of the issues with modern slavery, with organisations with quite large pay gaps, they're often the small companies. So I think until you change that, it won't have its absolute teeth. But obviously, they're balancing that between obviously the pressures on small businesses already. So it's quite a significant pressure. So I absolutely understand the need for the threshold, but if we're talking about prevention, I think there is some questions around that.
Yeah, absolutely.
I think that's it for this week. Covered a lot. As always, if you found this video helpful, please give us a like. Please subscribe both to the podcast and the Monday Morning Dispatch for the weekly updates. You can find us on Spotify as well as YouTube. We always say, Nils, leave us some comments. We like to talk about kind of topics that the listeners find interesting. Any questions you've got from us from a HR or a regulatory perspective, please let us know on comment on the video. Find us both on LinkedIn. Delighted to kind of answer any topics. I think we have one more podcast left before the bit of a summer break for us both. So lots to catch up with next week, both on modern slavery, and I'll probably have some updates on Employment Rights Act. So that's it, and thank you from me this week.
Thank you from me. Bye.